All right, folks, just got to adjust the camera here. Take a step back. Welcome just to another daily lecture on the Bill of Rights. Today's topic is the rights of the accused. Before we get started, though, just, things are getting a little out of hand here in the doctor household. COVID hair is, it's COVID hair. And you can see that shaving has become optional again. All right. So it'll be interesting to kind of proceed and see where this all ends up. All right, so the rights of the accused. Again, I have my notes down here in front of me, so I might not be looking at the camera the whole time, but just bear with me. I write extensive notes just to make sure that you receive all the information. I probably shouldn't write them out in like paragraph form because then it kind of I tend to want to read the notes to you. That's why I've switched on the camera, again, so that I don't become so monotone and robotic in the delivery of this information. All right, so first off, the rights of the accused. The rights you have if you are accused of a crime are encapsulated in the Fifth and Sixth Amendment. So we will also be doing some discussion of the Eighth Amendment because there are parts of the Eighth Amendment that deal with rights you have when accused of a crime as well. Some protections you have against government abusing its power. Okay, by the end, you should be able to list the rights you have if you are accused of a crime. You should be able to align those rights with the exact amendment numbers, and you should be able to identify some important court cases that have incorporated those rights to you as protections against state government intrusion as well. All right, so let's begin. So going back to the hip use finger game, I cannot stress enough how great of a tool this finger game is for remembering the content of the Bill of Rights. So, little mnemonic technique for the Fifth Amendment. You just hold up your fingers like this, boom, boom, boom. And one of the rights in the Fifth Amendment is, of course, your right to remain silent. So you just cover up your mouth. Okay. There are five. The genius of the mnemonic device and the Fifth Amendment. I don't know if the founders planned this, but there are five rights in the Fifth Amendment. Okay. Now, four of those rights are rights you have if you are accused of a crime. There is a throw-in right. I don't know why it's there. I could theorize as to why I think it's there. But anyways, there's one that actually doesn't deal with your rights if you are accused of a crime. All right, so the fifth, the mnemonic device, actually deals with the purple right there where it says, nor shall any person be compelled in a criminal case to be a witness against himself. So your right to remain silent. Okay? What that means is that you cannot be compelled to provide evidence against yourself. Okay, you might hear that. So in a court, you might be asked questions. You often hear it that people are pleading the fifth or taking the fifth when they refuse to answer the question because it might incriminate them in a criminal activity that they're not currently under investigation for. Okay. All right. That is kind of the blue one there. Now, going from the top to the bottom, in gold is your grand jury protection. Okay, this is an extra step that prosecutors have to take if you have been charged with a capital crime. A capital crime is one where the penalties are severe. In some states, capital crime leads to the death penalty. In other states, it leads to life in prison. So severe penalties. In that regard, we require government to go through an extra step. In fact, it is the grand jury that charges you with the capital offense, not government. A grand jury is going to be made up of 23 people. And the prosecutor would go before the grand jury and say, here's the evidence that I have. They're ensuring that the prosecutor has enough evidence to proceed with the prosecution, to proceed to trial. As a defendant, as the accused, you don't have many rights in a grand jury because it's really just as a protection against an overzealous prosecutor. Once you get to the actual trial, that's when your rights as a defendant kind of kick in. This is just an extra step that prosecutors have to go through. They want to charge you with a severe crime. All right, then on to the green. Nor shall any person be subject for the same offense to be twice put in jeopardy of life and limb, more commonly referred to as your double jeopardy protection. Okay, what this means is that government gets one shot. They accuse you of murder. They get one chance to prove you have committed that crime. They don't get to, if you're found not guilty, they don't get to charge you again and get a different jury and keep trying to find until they get it right and the jury actually convicts you. Can't do that. Okay, constitutional violation. However, there's misconceptions around double jeopardy. So it does not prevent the federal government and the state government both charging you with the same crime, because technically they're two different entities. It'd be two different laws. It also doesn't prevent a state from charging you with a different crime that was involved in the same sequence of events. So here's an example for you. Several years ago, probably close to a decade, if not more, there was this is a horrible, tragic example. There was a young woman from North Dakota, Drew Shadeen, who was kidnapped, brought to Minnesota, and murdered. And there was a man that was charged with this murder and this kidnapping. Now, it would not be a violation of double jeopardy if he was charged in kidnapping in North Dakota, because that's where the kidnap occurred. If he was charged with murder in Minnesota, because that's where the murder occurred, he could be charged with kidnapping by the federal government because the kidnapped person was taken across state lines. He could also be charged with the civil rights violation by the federal government. So 4 charges, all for the same sequence of events. None of them would violate the double jeopardy protection. Okay. All right, moving on to the black. In black, you have the due process clause, nor be deprived of life, liberty, or property without due process of law. So this one is huge. Really, when we talk about the rights of the accused, we're really talking about this is your due process rights. We're kind of laying them all out for you there. So what it means in simple terms is that if government wants to take your life, if government wants to take your freedom, if government wants to take your stuff, there's a process that they have to go through. There's a process afforded to you before you can lose those things. Okay? If you can remember due process as being a requirement that you have a right to a jury trial, you're on the right track. It's much more complex with that. We have substantive due process. We have procedural due process. You know that it gets complicated, but if you can remember that basic thing, that you are guaranteed a right to a jury trial before government can take your life, liberty, or property, you're in good shape. In fact, the more severe the penalties, the more extensive the process government has to go through. We can see that in the Fifth Amendment as well with the grand jury protection. All right, so Fifth Amendment, we've only talked about 4 of the rights yet, one being your right to remain silent, okay? But that is going to bring us to our first significant court case. All right, Miranda versus Minnesota, or Miranda versus Arizona. Now, why this is not a required Supreme Court case by AP, I have no idea. Okay, it's extremely significant court case. Now, Miranda was not a nice man. Okay, you don't ever want to be friends with this man. Okay, so here is the case. The facts of the case is Ernesto Miranda was arrested and interrogated by the police. He was unaware of and not informed of his Fifth Amendment right to remain silent, and his Sixth Amendment right to have, his right to an attorney. So he basically confessed to the crimes that he was accused of, and they were horrible crimes. He gave a confession while being interrogated by the police. So his case actually got appealed all the way to the Supreme Court. And the question before the court was, does the Fifth Amendment protection against self-incrimination extend to police interrogations of suspects? The court concluded, yes, it does. That the Fifth Amendment requires police to proactively inform suspects of their rights. If they don't do so, it would be a due process violation. It'd be unfairly taking away people's liberty. So now this requirement, and you see it all over in the news, you see it on TV and films, where the police, when you're subject to arrest, they're going to seize you, they're going to arrest you, they give you your Miranda warning. They read you both your Fifth and Sixth Amendment rights and making you aware of them. All right, so significant case. All right, moving on. So to that last right in the Fifth Amendment, the fifth right that really doesn't do with the rights of the accused. Okay, it's in red down there, and it says, nor shall private property be taken for public use without just compensation. This right down here, or this power of government, we call eminent domain. Less commonly, sometimes people refer to it as the takings clause. It allows government, okay, just to come in and take your property. There are two conditions they have to meet, but one of them does not have to be that you're accused of a crime. So you've done nothing wrong, okay? But government's going to come and take your property. The two conditions is they have to fairly compensate you for it, and they have to use it for public use, okay? So here's a real life example. Now this is two photographs of Mr. Anderson's dad's farm. Okay, it's up by Little Falls. It's right next to Highway 371. On the left, you can see a picture, an aerial view of the farm from 2004. And the western boundary, the left edge of the farm, abuts old Highway 371. You can see it there running north to south. And then on the right, you have an aerial image of Mr. Anderson's dad's farm in 2006. Okay, what happened in 2005 is that the government came in and they wanted to build new Highway 371. If you've ever traveled north to Brainerd, you traveled along this road. So in the image in 2006, you can still see old Highway 371 there, but then there's this, there's this 4-lane highway that's built just to the right of it, just to the east of it, that took huge swaths of Mr. Anderson's dad's farm. And because of eminent domain, the government can do this. There's nothing he could do to prevent them from taking the land. He could argue over just compensation. Was he fairly compensated for that land? Because the government, from Mr. Anderson's dad's perspective, it wasn't just the value of the land, but there was all the value of the crops that he would grow on that land that he would no longer be receiving. So was he fairly compensated for that? If he didn't think so, he'd have to sue and take it to the courts, and the courts would decide. Now, the second requirement here, okay, that the land be taken for public use is fairly clear. They built a public highway. That's public use. Okay, public use isn't always going to be as clear. So after you watch this screencast, go back in, watch the Constitution USA segment on eminent domain, because there is not so clear example of public use where government came in and took somebody's house and for a purpose that you could argue was not for public use. So that requirement's a little bit iffy. Right, moving on to the Sixth Amendment. Okay, so back to the mnemonic device. Again, I'm stressing these are great ways. So you go like this to construct 6. You cannot go like this because it won't work. You go like this, you got a 5 and a 1, and then you pretend, so Sixth Amendment, and then you pretend, boom, 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 that you're pointing to a watch. I don't wear a watch. Most people don't anymore, but you're pointing to it. You're reminding yourself of that first right there in the Sixth Amendment that you enjoy a speedy trial. Okay, that if you're accused of a crime, you have a right to a speedy trial. Okay, now the speedy trial protection is there so that government can't just delay and delay and delay and punish you by holding you in jail to your trial. Okay, you will also note in red there is a public trial protection, that your trial has to be public. Now, this is meant as an additional protection for you, the accused, so that the government can't hold a secret trial in a secret location. It is not meant as an additional right for the press, that they have access to your retrial. So reporters, the press, they can be legitimately just say, you can't come and see this trial. However, your trial cannot be closed to your family. Okay, it has to be a public trial in that sense. All right, moving on. In blue, you have by an impartial jury of the state and district wherein the crime shall be committed. So the blue text is where you see this is the second time in the Constitution where you'd see a guarantee of a jury trial, that it's a jury made up of your peers that is going to decide your guilt or innocence if it's a criminal trial. Now, what does peers mean? So the court has decided that when we say a jury of your peers, that means your neighbors, the people that live around you. It does not mean people of your same age. It does not mean people of your same gender or your race or religion. Just your neighbors. Those are your peers, okay? In green, we have and to be informed of the nature and cause of the accusation. That is your habeas corpus rights. So if you're accused of a crime, if you're arrested, you have the right to be brought before a judge and informed of what the charges are. Okay? Actually means show me the body, so you can't just be hidden away somewhere and no one's ever informed that you were arrested. Okay? In magenta, You have to be confronted with the witnesses against him. Okay, so this is your cross-examination protection. So when you are in a trial and you get to know who the witnesses are that the prosecution is going to bring to provide evidence against you, you get to know who they are. You also get to ask them questions as part of the trial. Okay, because maybe you can somehow, another use of the word impeach, you can establish that they have a bias against you, and you can, or that they might not be remembering the facts correctly. You can damage the character of the witnesses that were, and you might even be able to get information from them that supports your defense. Okay, so your cross-examination protection. Then after that, kind of in the light purplish color, to have a compulsory process for obtaining witnesses in your favor. This allows you to mount a defense. So in your trial, as the defendant, you have a right to bring your own list of witnesses. You basically have a right to establish a case in chief as the defense. You don't have to bring witnesses. The burden is on the prosecution to prove that you are guilty, but it's probably a good idea, and it's nice to have that right, that if you have good witnesses that can testify, that, provide evidence that you are innocent, then you can do that. Now in black, the last one, to have assistance of counsel. This is the one that has changed the most over time. So originally, we all understand this, that the Bill of Rights was only a protection against national government. So originally, you only had the right to assistance of counsel if the national government, the federal government, had charged you with the crime. If the state, and that's who we usually interact with when we talk about police power, it's the state that actually charges us with crimes. We did not have a right to a lawyer. Okay. Now, in addition, at the national level, that you talk about, if you can't afford one, we'll provide one for you. That was only true in capital cases. So cases where the penalty was death or life in prison. The national government would only provide you a lawyer if you couldn't afford one in those cases. Otherwise, if you couldn't afford one, you didn't get one. Okay? It wasn't until 1938 in Johnson versus Zerbst where they extended that protection to all federal cases, okay, regardless if they were capital or non-capital. However, that right still had to be incorporated to the states. Okay, now, so this next court case is the required AP case. You got to know this case, and it involves everybody's favorite kind of local hero, Clarence Earl Gideon. Okay, now Clarence Earl Gideon, there's a nice photo of him. He was a drifter. He was like a homeless person. He just traveled from town to town in Florida. He got odd jobs. He would live a little while and then he'd go on to the next town. Okay, so in 1961 in Panama City, Florida, someone broke into, smashed down a door, smashed up a cigarette machine, took some loose change from the cigarette machine, busted up a record player, and stole money from a cash register. Now, Clarence Earl Gideon was arrested for this crime, okay, and he was brought before the judge. And he specifically asked for an attorney to help him in his defense. And he was informed that Florida doesn't do that. Okay, they only did that in capital cases. Non-capital cases, non-felony cases, or actually, I should say it was a felony. But in non-capital cases, they would not provide you with a lawyer. So he got up there and he attempted to defend himself, to represent himself. He did not do a good job and he was found guilty. And this is where we've already heard this story a little bit because they messed with the wrong guy. Clarence did not give up. Using prison stationery, he wrote a petition for a writ of certiorari to the Supreme Court, and they granted the writ, and they heard his case. And the court basically came to the conclusion, okay, now I lost my notes here. There we go. The Supreme Court concluded that without the assistance of counsel, that Gideon's due process rights had been violated. That, without having that assistance, his freedom was unfairly taken away from him. So thanks to Clarence Earl Gideon, regardless of the state that you're living in, because this is the court case that incorporated that assistance of counsel in non-capital cases to the states, boom, you have that protection. Okay, if you get charged with a felony in North Dakota, California, Arizona, Minnesota, you have a right to an attorney if you can't afford one. The state will provide one for you. Thank you, Clarence. We appreciate that. especially those of us that have been charged with felony crimes. There. Now, the Eighth Amendment. A mnemonic device for the Eighth Amendment, it's a little loosey-goosey, but you probably get it. You basically take your hands, you choke yourself. It's to remind you that there is a protection against cruel and unusual punishment. Now, you focus on the words cruel and unusual, and you should come to the conclusion that the Eighth Amendment is another one of those spots in the Constitution that demands judicial interpretivism. Okay, you have to update this language to modern times, because what was cruel and unusual back in 1789 is not necessarily cruel and unusual today. Or what was considered, to be okay in 1789 is not considered to be okay today. Today we would consider that to be cruel and unusual. Now that is a protection that isn't necessarily for the accused. That's a protection for those that have been found guilty, as is the excessive fines. Okay, so if you've been found guilty and the penalty is to pay a fine, it can't be an excessive amount. That's meant to punish you beyond, what the crime actually might warrant. The excessive bail piece is in a protection for the accused. So bail is the money you would pay to promise that you would return to court for the trial. So you get arrested, you're thrown in jail, you post bail, you get to leave, you're promising you'll return. Okay, now excessive bail, the protection is there so that government can't use bail as a form to punish you. Now, we don't really have enough evidence. We're not sure we're going to be able to find this guy guilty. So let's just post the bail at like $100 million and then let's delay the trial. Okay, so they can't use bail as a punishment. Now, any discussion of the Eighth Amendment, we'd have to talk about the death penalty. Is it cruel and unusual punishment? So we've got two court cases related to the death penalty that you should be aware of, okay, for like a multiple choice test that we might have for this unit. They will not likely be on the AP exam because they're not required cases. Could you cite them? Yes, you could. Okay, you could bring in information from them if you thought that they were appropriate. So the first one I think is actually flipped around. I think it's Georgia versus Furman. Okay, in that case, here are the facts. Furman was burglarizing a private home, and he was kind of caught in the act. He was surprised while he was in the home. And in his efforts to leave the home, he tripped and fell, and the gun that he was carrying went off, and it shot one of the residents of the home, and that person died. So he was charged with murder, he was found guilty, and he was sentenced to death. All right? And his case went all the way to the Supreme Court. And the question before the court is, does the death penalty constitute cruel and unusual punishment? And with this case, with these circumstances, the court said, yes, it does. And they pointed to this. I'm going to read this because I want to make sure I get it right here. The court pointed to the arbitrary nature with which sentences were imposed, often indicating a racial bias against Black defendants. So they said, you know what? It's unconstitutional. So there was a 4-year period of time where the death penalty was unconstitutional across the whole country. And states had to go through their laws and basically make sure that the application of the death penalty was not arbitrary and was not racially biased. Okay, so Georgia did that. They kind of revised their laws about how they would apply the death penalty and to which cases it would be a legitimate penalty. And then they reinstituted it. So 1975 rolls around and you have another case with this new death penalty law in Georgia. And it was Gregg versus Georgia. Now, Gregg was a guy who was arrested for armed robbery and murder. Okay. And he was sentenced to death. And so he sued and he claimed that the death penalty violated the Eighth Amendment. Now, in this case, Gregg versus Georgia, the Supreme Court said, no, it doesn't. They said the death penalty did not violate the Eighth Amendment in all circumstances. And they pointed to murder itself is probably an appropriate penalty. Death penalty is an appropriate penalty for murder. They also pointed to the fact that the Georgia law required additional due process steps to make sure that it wasn't applied arbitrarily and that there wasn't a racial bias in its application. All right. Now, a couple more things on the death penalty. Just kind of throw them out there. So a few more slides. Boom. This slide is actually a few years old now, so these numbers have increased. But here you can see the number of people that were put to death by each state since the reinstitution of the death penalty in 1976. Okay, so you look at that, what you should learn from this slide is that you don't want to be accused of a capital crime in Texas. Okay. The other thing is that even though the Supreme Court has found that the death penalty itself, is constitutional in some circumstances, the method might not be. Okay, so there's been some recent news stories the last couple of years about using the lethal injection as a method for, causing death. Okay, and there's been times where it didn't work. So here's the thing. Is it unconstitutional? Is it cruel, unusual if the government has to put you to death twice? The first time they try, it doesn't work. You survive it. So they have to do it again. Is that unconstitutional? So the method used actually could. What is going on here? Okay. I found this on the web for you. My Siri turned on. You must have thought I said Siri at some point. All right. So the method used could be unconstitutional. And then a couple other things here. So not necessarily the death penalty, but what about interrogation techniques that were used in the war on terror? So in this picture here, you can see the sensory deprivation techniques that were used in Guantanamo Bay, Cuba. Is that a violation of the Eighth Amendment? Okay. And then we have determined, the court says that, using the death penalty on minors is unconstitutional. Using the death penalty on people of limited mental capacities, okay, is unconstitutional. But what if you have a minor who's then been charged as an adult? Is the death penalty constitutional then? You could check out the court case. All right, so a couple things to remember, just to review. The rights of the accused are encapsulated in the Fifth and Sixth Amendment. With the Fifth Amendment, here's your mnemonic device. Remember, there are 5 rights, one of which is your right to remain silent. The other ones to remember are your grand jury protection, your protection against double jeopardy, and then, of course, the due process clause, that there is a process government has to go through if they want to take your life, your liberty, your freedom. Your stuff, your property. Sixth Amendment, 6 rights, one of which is the speedy trial, and the other 5 all deal with trial rights as well. So you have a right to a speedy and public trial, you have a right to a jury of your peers, and you have the right to assistance of counsel. Thank you, Clarence. Some court cases to remember. Number 1, Miranda versus Arizona. Remember, it's a Fifth Amendment case because it requires that the police proactively inform you of your rights. If they don't do so, then they're unfairly violating the due process clause. So your Miranda warning is basically a reminder that you have certain Fifth, certain Sixth Amendment rights. Gideon versus Wainwright incorporated your right to counsel in all cases, all felony cases, to the states. So you have that protection now. Eighth Amendment, for your protection against cruel and unusual punishment. The excessive bail, that is a protection we would include with the rights of the accused, but it also protects you against excessive fines as well. All right, on Monday, we'll kind of fill in the gaps of the amendments that we haven't actually covered. Thank you for your time, and we'll see you guys. All right, and now I have to remember how to stop this. I think I forgot. There we go.